Hi, I am George. Welcome to this comprehensive lecture on the laws of divorce under Seychelles law. Today, we embark on a detailed exploration of the legal framework governing marital dissolution in Seychelles, a topic of profound importance and complexity in our legal landscape. Seychelles upholds the sanctity of marriage while also recognizing the realities and challenges that can lead to its dissolution. Our discussion today will delve into the pertinent provisions of the Civil Code of Seychelles, alongside statutory interpretations that shape divorce proceedings in our jurisdiction. We will begin by examining the grounds for divorce recognized under Seychelles law, highlighting both the fault-based and no-fault paradigms. This examination will include a discussion on the implications of these grounds, the evidentiary standards required, and the legal nuances involved. Let us embark on this journey of legal exploration with an open mind and a keen sense of inquiry as we delve into the laws of divorce under Seychelles law. Trapped in the confines of a loveless marriage, one might wonder, what is my escape route? How do I disentangle myself from my husband or wife in the marriage? The answer lies within the law's labyrinth. The path to liberation through divorce. A person who seeks a divorce from his or her spouse has to prove one of 5 grounds. The consequences of being granted a divorce by the court are that your marriage is legally dissolved, and you are no longer obligated to perform certain conjugal duties and discharge matrimonial responsibilities towards your spouse, which are created by marriage. Marriage, a legal contract or a personal vow. What is the legal definition of a marriage? Consider marriage not just a union of hearts, but a contract of utmost sincerity. It's an agreement that lays the foundation of family life, a solemn accord that shapes destinies. Marriage is, therefore, defined as a contract between two adults. The marriage contract, obligations and expectations. The Civil Code Act speaks of it in contractual terms, binding two souls in an intricate dance of duties and expectations. Let's dissect these obligations and how they form the very fabric of marital life. Like any other contract, a contract of marriage creates obligations, duties, and responsibilities imposed by law. That is why the word contracted is used in several instances when referring to a marriage in the Code. Under the heading Marriage on page 9, Article 146 of the Civil Code Act 2020, which is at the very beginning of the Code, the law states that a marriage cannot be contracted before the dissolution of an existing marriage. Further, on page 17 of the Code at Article 201 under the heading Marriage Obligations, several obligations are imposed on both the man and the woman who contracts a marriage. For instance, under Article 201, the law provides that the spouses owe to each other faithfulness, support, assistance, and care. And at Article 203, the law provides that the spouses jointly, by the mere fact of the marriage, undertake the obligation to maintain and bring up their children. The requirement of consent. Without consent, there is no marriage. This is the law's heartbeat. Together, we will examine the profound importance of consent in marriage and its role as the guardian of free will within the matrimonial pact. Article 145 of the Civil Code states that there is no marriage where there is no consent. The Online Legal Information Institute states that, in the English common law tradition from which our legal doctrines and concepts have developed, a marriage was a contract based upon a voluntary private agreement by a man and a woman to become husband and wife. Marriage was viewed as the basis of the family unit and vital to the preservation of morals and civilization. Traditionally, the husband had a duty to provide a safe house, pay for necessities such as food and clothing, and live in the house. The wife's obligations were maintaining a home, living in the home, having sexual relations with her husband, and rearing the couple's children. Today, the underlying concept that marriage is a legal contract still remains, but due to changes in society, the legal obligations are not the same. There are essentially 5 grounds for divorce. Article 227 of the Civil Code 2020 deals with the dissolution of marriage. It provides that a marriage may be dissolved in one of 2 ways, either A, by the death of one of the spouses, or B, by divorce. Article 230 of the Code provides for the grounds of divorce. There are primarily 5 grounds upon which a party to a marriage may petition the court for divorce. A party who petitions the court for a divorce does not have to allege or prove all 5 grounds to be granted a divorce. It is sufficient to allege and prove any one of the 5 grounds only. A party to a marriage may petition for divorce on one of the following grounds, namely, that the marriage has irretrievably broken down because A. The respondent has committed adultery, and the petitioner finds it intolerable to live with the respondent, or B. The respondent has behaved in such a way that the petitioner cannot reasonably be expected to live with the respondent, or C. The respondent has deserted the petitioner for a continuous period of at least 2 years immediately preceding the presentation of the petition, or D. The petitioner and the respondent have lived apart for a continuous period of at least 1 year immediately preceding the presentation of the petition, and the respondent consents to the grant of the divorce, or E. The petitioner and the respondent have lived apart for a continuous period of 5 years or more. 2. Subject to paragraph 3. A party may not petition for divorce until after 1 year from the date of the marriage. Let's examine what is the definition of adultery in law, and what you need to prove in court in order to get a divorce on this ground. 1. Adultery. In the context of Seychelles law, adultery is traditionally defined as a voluntary sexual relationship between a married individual and a person who is not their spouse. This definition aligns with the general principles of common law, which Seychelles partly inherits, considering its historical association with British legal traditions. The essential elements of adultery are the marital status of one party and the voluntary engagement in a sexual act with someone outside the marriage. Proving adultery in court, particularly within the jurisdiction of Seychelles, can be challenging due to the nature of the evidence required. The standard of proof in civil cases like divorce is on the balance of probabilities, which is less stringent than the criminal standard of beyond reasonable doubt. However, adultery must still be proven with sufficient and credible evidence. The methods to establish adultery in court typically include direct evidence. This is the most straightforward but least common form of evidence. It includes eyewitness accounts or video photographic evidence of the adulterous act. However, due to the private nature of such acts, direct evidence is rare. Circumstantial evidence. More commonly, adultery is proven through circumstantial evidence. This includes things like messages, emails, or photographs that suggest an intimate relationship, hotel or travel records showing the couple together, or testimony from private investigators. Admission of guilt. Sometimes, adultery can be proven if the accused admits to the act. This can occur during the divorce proceedings or in written communication. Pregnancy or birth of a child. If a child is born that cannot be attributed to the husband, considering factors like timing and fertility, it may serve as evidence of adultery. Reputation and behavior. Evidence may also come from the reputation or general behavior of the parties involved. Witness testimonies about public displays of affection or cohabitation can be relevant. Technology and social media. In contemporary times, evidence from social media, text messages, and other digital footprints can play a crucial role in establishing adultery. It's important to note that the court does not require absolute proof of the physical act of intercourse. Instead, evidence that suggests a high probability of sexual relations having occurred is often sufficient. Legal representation in such matters is crucial, as a lawyer can help navigate the complexities of gathering and presenting evidence in a manner that is admissible and persuasive in court. Lastly, Seychelles, like many jurisdictions, is subject to evolving legal standards and interpretations. Therefore, it is advisable to consult with legal professionals who are up to date with the latest legal precedents and practices within the jurisdiction. 2. Unreasonable behavior. The respondent has behaved in such a way that the petitioner cannot reasonably be expected to live with the respondent. In the context of divorce law, unreasonable behavior is a ground for divorce that is often used when one spouse alleges that the other has behaved in such a way that they cannot reasonably be expected to live with them. It is a subjective test that varies from case to case, as what may be unreasonable for one person to live with may not be unreasonable for another. The definition can encompass a wide range of behaviors, from serious issues like physical violence and substance abuse to less severe but still significant issues like lack of emotional support or financial irresponsibility. To establish unreasonable behavior in a court in Seychelles or elsewhere, The petitioner must provide evidence that the respondent has behaved in such a way that the petitioner cannot reasonably be expected to live with the respondent. This involves demonstrating a pattern or serious instances of behavior that lead to the breakdown of the marital relationship. The petitioner typically provides a series of allegations that outline the nature of the unreasonable behavior. Here's how one might prove unreasonable behavior in court for divorce proceedings. Written statement. The petitioner usually starts by preparing a written statement or affidavit that details specific instances of the respondent's unreasonable behavior. This statement should be as clear and detailed as possible, outlining dates, events, and the impact of the behavior on the petitioner. Supporting evidence. Evidence to support the claims could include communications between the parties, texts, emails, letters, medical records, if the behavior has caused health issues, financial records, if the behavior involves financial irresponsibility, or police reports, in cases of serious issues like violence. Witness testimonies. Witness statements from friends, family members, or professionals who have seen the impact of the behavior on the petitioner can also be used. Corroborative evidence. If the unreasonable behavior relates to addiction or criminal activity, any official records or expert testimony can be used to corroborate the petitioner's claims. Respondent's acknowledgement. In some cases, if the respondent does not contest the allegations of unreasonable behavior, their lack of defense can be seen as an acknowledgement of the behavior, which can simplify the process. The court will consider the totality of the evidence presented to determine if the behavior is indeed unreasonable, and if it is unreasonable enough to warrant the dissolution of the marriage. It's essential to note that cultural norms and societal expectations may play a role in what is considered unreasonable within a particular jurisdiction. In Seychelles, as in many jurisdictions, the specifics of these grounds for divorce and the standards required to prove them can be nuanced and require the guidance of legal counsel well-versed in local family law. 3. Desertion. Desertion, in the context of divorce law, refers to a situation where one spouse abandons the other without consent, without a reasonable cause, and with the intent of ending the marital relationship. Under Seychelles law, as in many common law jurisdictions, desertion must meet certain criteria to be considered a ground for divorce. The legal definition of desertion typically includes the following elements. Physical separation. One spouse must have physically left the marital home. Intention to desert. There must be an intention on the part of the absent spouse to desert the other. This is a subjective element and goes to the state of mind of the deserting spouse. Lack of consent. The separation must be without the consent of the other spouse. Lack of justification. The separation must be without good cause. If the spouse who left did so because of the conduct of the other, for example, abuse, this might not be considered desertion. Duration. The desertion must have continued for a specific period, usually a statutory period, which may be defined by local legislation. Often it is for a continuous period of at least 2 years. To prove desertion in a Seychelles court and obtain a divorce on this ground, the petitioner would typically need to establish the following. Evidence of separation. Show that the spouse has been absent from the marital home for the period required by law. Evidence of lack of consent. Provide communication or testimony that demonstrates that the separation was against the petitioner's wishes and that they did not agree to it. Evidence of lack of justification. Establish that there was no reasonable cause for the spouse to leave the marital home. This might involve showing that the petitioner did not commit any act that would justify the other spouse's departure. Evidence of the intent to desert. Demonstrate the other spouse's intention to desert, which can be inferred from circumstances such as not providing support, not communicating with the petitioner, or engaging in conduct that shows a disregard for the marital relationship. Attempt at reconciliation. Show that the petitioner made attempts to reconcile, or at least did not refuse any genuine attempts at reconciliation. Duration. Provide documentation or evidence that the desertion has lasted for the statutory period required by the law, without interruption. It is important for the petitioner to provide a comprehensive collection of evidence to support the claim of desertion, as it can be a complex ground to prove due to its subjective nature concerning intent. Legal advice and representation by a lawyer with expertise in Seychelles family law would be crucial to navigate the nuances of proving desertion in court. 4. living apart for 1 year before filing for divorce. The petitioner and the respondent have lived apart for a continuous period of at least 1 year immediately preceding the presentation of the petition, and the respondent consents to the grant of the divorce. This is what is commonly known as a no-fault divorce. To prove that the petitioner and respondent have lived apart for a continuous period of at least 1 year, immediately preceding the presentation of the petition, and that the respondent consents to the grant of the divorce under Seychelles law, the following steps and pieces of evidence can be presented. Documentary evidence of separation. Evidence such as separate residential addresses, utility bills, rent agreements, or property deeds can substantiate the claim that the parties have been living apart. These documents should clearly show the names and separate addresses of the parties and cover the period in question. Affidavits or statements. Both parties may provide written statements or affidavits confirming the date on which they began living apart, and that the separation has been continuous and without interruption for at least 1 year. Corroborating witness testimony. Friends, relatives, or neighbors can provide witness statements or appear in court to testify that the parties have been living separately for the required time. Respondent's consent. The respondent's consent can be evidenced through a written statement or affidavit indicating their agreement to the divorce. Alternatively, if the respondent has indicated consent through their actions, such as not contesting the divorce or cooperating with the proceedings, this may also be considered consent. Official correspondence. Any official correspondence or communication between the parties during the separation period can support the assertion that they have been living apart. This might include emails or letters discussing the separation or other matters related to living independently. Evidence of separate lives. Additional evidence that the parties have led separate lives might include separate bank accounts, separate insurance policies, or evidence of separate social lives. Petition for divorce. The petition for divorce itself should clearly state the period of separation and the fact that the respondent consents to the divorce. Service of proceedings. Proof that the divorce proceedings have been duly served on the respondent and that they have acknowledged receipt of the same will also be necessary. The court will evaluate the evidence to determine whether the criteria have been met. If the respondent consents to the divorce, they may also file a response with the court affirming their consent to the divorce proceedings. In cases where everything is in order, the court will proceed with granting the divorce, assuming all other legal requirements are met. It's always recommended that parties seeking a divorce under such grounds consult with a legal professional who can ensure that all evidence is correctly presented and that the legal process is properly followed. 5-year separation. Living apart for 5 years. To prove that the petitioner and the respondent have lived apart for a continuous period of 5 years or more, which is typically a ground for divorce that does not require the respondent's consent, the petitioner must present clear and convincing evidence to the court. Here's how one might establish this in a Seychelles court. Documentary evidence of separate residences. Provide utility bills, rent receipts, leases, or property deeds that show separate addresses for the petitioner and respondent over the 5-year period. Affidavits or written statements. The petitioner can submit a sworn affidavit or written statement detailing the history of the separation, including the date it began and asserting that it has been continuous. Affidavits from third parties who are aware of the separation can also be helpful. Witness testimony. Friends, family members, or colleagues can testify that the parties have lived separately for the required period. Their testimony can corroborate the petitioner's claim regarding the separation. Official records and correspondence, showing that the petitioner and respondent have conducted their lives independently, may include separate tax returns, separate bank accounts, and individual financial transactions over the 5-year period. Evidence of independent lives. Evidence that both parties have lived their lives as if they were single, such as engaging in social activities separately, can support the claim of living apart. Attempts at reconciliation. If there were any attempts at reconciliation, it should be shown that these did not interrupt the 5-year period of living apart. Any brief periods of cohabitation, if they occurred, should be explained and shown not to have constituted a resumption of marital cohabitation. Communication records. If there is correspondence between the parties discussing their separation or issues related to living apart, this can serve as evidence. Petition for divorce. The divorce petition should clearly state the date when the parties separated and assert that the separation has been ongoing for at least 5 years. It is important to note that living apart does not necessarily require physical separation. The courts will consider whether the marital relationship has effectively ended. The parties may reside under the same roof, but lead completely separate lives, and this may still be considered living apart, although this is often more difficult to prove. If the respondent disputes the claim of having lived apart for 5 years, then the burden is on the petitioner to prove otherwise. The courts will consider all the evidence presented to determine whether the petitioner has met the burden of proof for this ground of divorce. Because proving a period of separation can be complex and the legal standards may vary, legal advice from a professional familiar with Seychelles family law is crucial to ensure that evidence is properly presented and that procedural requirements are met. The legal requirement of attempt at reconciliation. Article 231 of the Code. Another stumbling block to the attainment of a divorce in Seychelles is the legal requirement that the party who petitions the court for divorce must prove that there has been at least one attempt at reconciliation before a divorce would be granted by the court. Article 231 of the Code prevents the court from granting an order of divorce if there is no evidence of reconciliation. It provides as follows. 1. The court shall not grant a divorce unless it is satisfied that a. An attempt has been made to reconcile the petitioner and the respondent, and b. After inquiring into the evidence presented by the parties to the proceedings, there is no reasonable possibility of reconciliation between the parties, and c. The marriage has irretrievably broken down. 2. The court shall, if it appears to the court at any stage of the proceedings for divorce that there is a reasonable possibility of reconciliation between the parties, adjourn the proceedings for such period as the court thinks fit to enable an attempt at reconciliation to be made. Conclusion. As we conclude our exploration of the matrimonial journey through the lens of the Civil Code Act 2020, let us pause to consider the gravity and profundity of marriage and divorce within our legal framework. Marriage, as we have seen, is far more than a simple union of two individuals. It is a legally binding contract that weaves together the lives, fortunes, and fates of those involved. It creates a complex tapestry of duties, obligations, and rights that extend beyond the personal and into the realm of legal obligation. Divorce, then, is not merely the end of a personal relationship, but the legal disentanglement of this intricate web. It is a process that demands careful, compassionate consideration, particularly where children are involved. The Civil Code acknowledges the depth of this process, providing a structured path that respects the individual's rights while upholding the sanctity of the familial bond. In delving into the substance of the Civil Code Act, we have uncovered that the essence of marriage and divorce transcends the written word and enters the domain of human experience. Each article and clause is a reflection of the society's values, a narrative of its understanding of personal freedom, mutual respect, and the inherent dignity of each individual within the marital union. Therefore, let us step forward from this discussion with a renewed appreciation for the law's role in guiding us through life's most personal and profound passages. May the knowledge we have shared today empower us to approach these matters with both the wisdom of the law and the empathy of the human heart. Do not forget to hit the like and subscribe buttons for more content on this channel. Ciao, ciao.